Right, court will go back on the record in case number 1043, State of Texas versus Marcan Denise Barnes. Right, Mr. Seeloff, when I ask you if you are ready, you ask for a chance to talk to your client. Are you now ready?
We're ready, and we're ready, Your Honor, and we would like a ruling on our application for writ of habeas corpus that was filed on January 24th, 2023.
Let's see if I can find that in the file. Can you see that?
Your Honor, this motion was about the reason that the main motion to revoke that was initially filed with this case.
I found it.
Okay.
All right, Mr. Seeloff, you may proceed on that motion.
So on February 23rd, on the motion that I filed, Your Honor, on February 23rd, 2021, the court signed an order of arrest for the defendant for state's motion to adjudicate and make a final disposition. We're arguing, Your Honor, that the court, the order was based on a deficient motion. There was no signature of an attorney representing the state on that motion that was initially filed. And the only other valid motion that was signed by the state that we have, Your Honor, is a motion to adjudicate that was presented to the court December 16th, 2022. So we're arguing that it was over 8 months after the defendant's probation was due to expire. So since there's no valid motion presented to the court until after the probation term was up, we're arguing that the motion can't be heard and the court doesn't have jurisdiction to hear this case.
Do you have a response, Ms. Anchondo?
I do, Judge. That's incorrect. This has already been determined by Falana v. State. That's a 2000 case out of Fort Worth. Essentially, it says the Court of Criminal Procedure requires a signature on an indictment, requires information, which later is analyzed by the Amarillo Court of Appeals. But it specifically says that in the Code of Criminal Procedure, there is a requirement that the defendant have pleadings signed by at least one attorney of record. It points out that it has no similar counterpart specifically requiring states pleadings, such as a motion to adjudicate, to be so signed. And then the Amarillo Court of Appeals last year in Munguia v. State, it looks like this was from April 22nd of 2022 when it was decided, says that in reference to Falana talking about charging instruments not being signed, says, nevertheless, the lack of signature from a charging instrument does not render the instrument invalid. All we need to look at is whether or not the accused was provided adequate notice of the charge against him. The instrument must be properly presented to the court, and filing it with either the judge or the clerk of the court satisfies that requirement. Both of those things have been satisfied in this case. The defendant was provided a copy of the motion, and even though the first one was not signed, that does not render it invalid, as is reflected by both of those cases and other cases citing to both of those. So we were all ready to proceed on our motion, Judge.
Ms. Anchondo, do you have the site to Munguia?
Yes. Munguia v. State. It looks like 2022 Tex App Lexus 2649.
While I'm looking at this, Mr. Seeloff, do you have a response?
I'm trying to look at the site right now, Your Honor, but that's what I was asking about. But we still argue it was inadequate notice because it was not signed by the state.
And Judge, our response is the notice is the motion, whether or not I signed it or not, according to the case law, doesn't render it invalid. The notice is in the body of the motion.
Now, I'm not seeing in Munguia that it deals with a signature on the document. Is that the case, Ms. Anchondo? Is this more of a notice?
Correct.
Position?
And so it looks like on, let's see, when Falana discussed the motion to adjudicate not being signed, that was on, oh my goodness.
How do you spell Solana?
It's Falana. I have the hard copies that I was reading off of, Judge, if it's easier for me to have Brandon run them down to you with the
No,
highlighted sections.
What year is Solana?
2007.
And that's Solana v. State?
Yes.
There's no D?
No. It looks like it's 2000. The call that, or the site that I have is 2007 Texas app Lexus 9608.
I don't
Are you
have,
using Westlaw?
I'm using Westlaw.
Okay, 2007 WL 4292390. And the section is under the lack of signature on third petition. On my end, it shows head note 1, although the Code of Criminal Procedure, and it's that first sentence.
And that's S as in Sam or F as in Frank?
F as in Frank.
Oh, okay. Alana v. State could be more helpful if it had not basically been decided on the issue that the defense failed to object.
And Judge,
However,
go ahead.
Go ahead. No, please go ahead.
So in citing Munguia from 2022, they reference the Falana case and finding the difference between a motion to adjudicate and then a charging instrument is there's a statute that requires the charging instrument to be signed. However, the Amarillo Court of Appeals cites to Falana, which deals with the motion to adjudicate, saying that the lack of a required signature under an indictment or information still isn't fatal, so long as that there's notice. And so that's where in the next paragraph in Munguia, it goes through, she has to have notice of the charge against her. It has to be properly presented to the court. And so certainly if a signature is statutorily required in a complaint or an information, or I'm sorry, an information or an indictment, and it's still not fatal, citing Falana, then the motion to adjudicate, which there is no statute requiring that the state's motions be signed, it definitely shouldn't be fatal in this situation. And she was given proper notice. And so that's why we argue that Falana and Munguia control in this situation.
Mr. Seeloff, I'm going to overrule that application for a writ of habeas corpus, and let's proceed on the second motion, the state's second motion requesting adjudication. Ms. Enchando, that is your motion. You may proceed.
Okay, Judge, the state's ready. I'm not sure what Ms. Barnes's plea is.
All right, Ms. Barnes, let me ask you, are you the same Marcan Denise Barnes that previously pled guilty in 2019 to the offense of possession of a controlled substance?
Yes, ma'am.
And at that time, and that was a second-degree felony, is that correct?
Yes, ma'am.
At that time, a finding of guilt was deferred and you were placed on community supervision for a period of 3 years. Is that correct?
Yes, ma'am.
The state is now alleging that you violated the terms and conditions of your probation in that in May of 2020, you failed to abstain from the use of narcotics or drugs, specifically methamphetamine, and July of 2020, you again failed to abstain from methamphetamine. November 11th of 2019, you failed to abstain from the use of cocaine. In September of 2019, you failed to abstain from the use of marijuana. August of 19, you failed to abstain from the use of marijuana. You failed to report to your probation officer in Parker County on a number of dates between August 2020 and December of 2022. You failed to submit to a urine test on July of 2020, June of 2020, and January of 2020. You failed to pay court-ordered probation fees on a number of occasions between September of 2019 and December of 2022. You failed to complete the marijuana awareness course and outpatient treatment. You failed to report in writing to the 69th Judicial District Probation Department on October, November, and December of 2020 and January of 2021. You failed to complete 120 hours of restitution. You committed the offense of possession of a controlled substance, specifically methamphetamine, on September 2022 in Parker County, and you committed the offense of possession of marijuana on September of 2022 in Parker County. To the state's allegations, do you plead true or not true?
Some of those are true and some of those are not true.
Which ones are not true?
Well, the testing I guess, of the first two of methamphetamine and cocaine is not true. But
Your
I
Honor,
do-
may
Yes,
I go
Mr.
through? May I go through with Ms. Barnes line by line to see which ones she says are true and not true?
You may.
Okay. Ms. Barnes, can you hear me?
yes.
They want to be,
Yes, sir.
Okay.
no.
The first one was about use of methamphetamine on or about May 27th, 2020. True or not true?
Not true.
B is failed to abstain from methamphetamine on or about.
Let me excuse you. I'd like to have Miss Barnes sworn, please.
Oh, sorry.
Ms. Barnes, please raise your right hand and be sworn. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God?
Yes.
Thank you. You can put your hand down.
All right, Mr. Seeloff, please ask again about the first allegation.
Ms. Barnes, on or about May 27th, 2020, you used methamphetamine. True or not true?
Not true.
B is failed to abstain from methamphetamine on or about July 23rd, 2020. True or not true?
Not true.
Failed to abstain from use of narcotics, namely cocaine, on or about November 11th, 2019.
Not true.
You failed to abstain from the use of narcotics, namely marijuana, on or about September 10th, 2019. True or not true?
True.
You failed to abstain from the use of narcotics, namely marijuana, on or about August 8th, 2019.
True.
You failed to report in person to the Parker County Community Supervision on the 10th of each month, starting from August 2020 to December 2022. True or not true?
Not true.
You failed to submit a urine testing on July 2nd, 2020, June 19th, 2020, and January 21st, 2020. True or not true?
Not true.
You failed to pay court-ordered fees on or before the 10th day of each month, starting from September 2019 to December 2022. True or not true?
Not true.
You failed to complete the marijuana awareness course and outpatient treatment as recommended by a community supervision officer. True or not true?
It is untrue.
You failed to
I'm sorry.
report in writing to the sixth.
Sorry, what was the answer to that?
She said, I'm sorry, what did you say,
Not
Ms. Barnes?
true. Not true.
You failed to report in writing to the 69th Judicial District Community Supervision and Corrections Department on or before the 10th day of each month, starting from October 2020, November 2020, December 2020, and January 2021. True or not true?
Not true.
You failed to complete 120 community service hours.
Seeloff. Miss Barnes, did you say true or not true?
Not true. Well, because in December, I
Ms.
did. in
Barnes?
December-
Ms. Barnes, true or not true?
Not true.
You committed the offense of possession of a controlled substance, namely methamphetamine, in Parker County, Texas, on or about September 6th, 2022.
True.
You committed the offense of possession of marijuana on or about September 6th, 2022, in Parker County, Texas.
True.
I just want to make sure again, Ms. Barnes, you committed the offense of possession of controlled substance, namely methamphetamine, in Parker County, Texas, on or about September 6th, 2022. Is that true or not true?
True.
Okay. That's it, Your Honor.
Did we get K, Daniel? I'm sorry, on the restitution hours?
The 120, I think she said not true.
Not true. Okay.
Is that correct, Miss Barnes? Did you fail to complete 120 hours of community service?
Not true.
So you're saying you did complete your your
I turned in
community service.
blankets. Not true. Yes, ma'am.
Ms. Barnes, having pled true to some of the state's allegations, is there a plea agreement in this case, Ms. Anchondo, or do you wish to proceed with your evidence?
There is not a plea agreement, Judge, but I do ask to dismiss my witnesses related to L and M. Deputy Jeremiah Kaleem and the forensic chemist Christina Garza.
They may be dismissed. Are they on where they can hear us? I guess my court reporter tells me no, so you may contact them and tell them they may be excused.
Okay, Brandon is going to try to do that through email. They generally don't respond to phone calls during. Is that how they were responding last time? Okay, he's contacting them right now.
Or we could bring them in. Would that be easier?
That's I think would be
Okay.
better, Judge.
Hello?
Yes,
All right. And Shonda, you may proceed.
Ms. Garza and Deputy Kaleem, can you both hear me? Oh, he's connecting to audio right now.
Yes, ma'am.
Ms. Garza, Ms. Barnes, the defendant here, has pleaded true to the allegations concerning the controlled substance. So you are excused. I'm sorry that this has taken up your morning, but this will be, we're not going to subpoena you again. And Deputy Kaleem, same with you. Ms. Barnes, the defendant, has pleaded true to the allegations concerning the offense to which you witnessed. And so you are excused. I appreciate your patience with us this morning.
Thank you, ma'am.
Thank you.
All right. To the participants, it is noon. We could take a lunch break here. I'm going to ask if the jail is going to be able to be back with us at 1:30.
Yes, ma'am.
Right, then we will be in recess until 1:30. Well, let's say 1:15. We'll be in recess until 1:15.
Yes, ma'am.
All right, thank you.